Hello everyone, welcome to the Black Social Law Academy. Today we are learning Article 15. I guarantee you by the end of this video, Article 15 will be absolutely clear to you. So Article 15. Article 15 Clause 1 says that the state shall not discriminate against any citizen only on certain ground. Who is restricted under Article 15 Clause 1? The answer is only state. So applies to state. So the private individuals are not covered here. This clause applies only to the state defined under Article 12. Okay. So who is protected under Article 15 Clause 1? Only citizens. This protection is available exclusively to Indian citizens. Okay. The foreigners cannot claim the protection under Article 15. This is citizen specific right, unlike Article 14. If you have not watched the Article 14 video, please watch it out. Then grounds of prohibited discrimination. So Article 15 clearly lists them: religion, race, caste, sex, place of birth. And remember one crucial word used here only. That word is very important for exam. So the state is prohibited from discrimination only on these grounds. That means if discrimination is based solely on one of this ground, that is unconstitutional. If it is based on additional valid reasons, it may be allowed. Okay, let us understand this with simple situation. Imagine this scenario: a state run engineering college issues a notification saying only male candidates are eligible to apply for this course. Now ask yourself, so is this college a state authority? Yes, it comes under Article 12. So is the discrimination based only on sex? Yes. So male candidates are eligible. So this is a prohibited ground under Article 15 Clause 1. So this action becomes unconstitutional. Why? Because the state cannot discriminate only on the ground of sex. Now let us move to Article 15 Clause 2. This clause is very powerful because it goes beyond the state. So Article 15 Clause 2 applies to the state in the private individual also. So this is a major difference between Article 15 Clause 1 and Article 15 Clause 2. What does Article 15 Clause 2 protect? Article 15 Clause 2 ensures a equal access to shop, then public restaurant, hotels, places of public entertainment, well tank, bathing gas, road and public resorts. So maintained wholly or partly out of state funds or dedicated to public use. So grounds are the same. The grounds of discriminations are the same as Article 15 Clause 1: religion, race, caste, sex, place of birth. So okay, then now imagine this situation. A public restaurant refuses to serve food to a person because they belong to a scheduled caste. Okay, so ask this question: is the restaurant a public place? Yes. Is denial based only on caste? Yes. This is given scheduled caste. Okay. Yes. So what happens? This is a clear violation of Article 15 Clause 2. Even though the restaurant may be a private owned, so once it is open to the public, discrimination is prohibited. Now comes Article 15 Clause 3. Article 15 Clause 3 says nothing in this article shall prevent the state from making any special provision for women and children. What type of clause of this? This is an enabling clause, meaning the state is allowed to do something. Okay, it is not forced but permitted. So this clause allows a positive discrimination. Why is this not violation of equality? Because the goal here is substantive equality, not formal equality. So women and children are historically disadvantaged. So the Constitution allows special protection. Okay. For example, Article 42, maternity relief, and educational institution exclusively for women, free education for child, and then law preventing exploitation of children. All this are constitutionally valid. Now let us move to Article 15 Clause 4. So this clause is extremely important because this is where the reservation law really begins. So why was Article 15 Clause 4 introduced? Let me ask you a question. If the Article 15 prohibits discrimination, how can reservation exist? So this confusion arose in the case State of Madras versus Chempakadurai Rajan. So the State of Madras introduced communal reservation in educational institution. Okay. So the Supreme Court held reservation based purely on the case violates Article 15 Clause 1 and Article 29 Clause 2. As a result, the reservation policy was struck down in this case. Okay. So what did the Parliament do? It introduced Article 15 Clause 4 through the First Amendment. So First Constitutional Amendment Act 1951. So Article 15 Clause 4 starts with a non-obstantee clause. That means it operates notwithstanding Article 15 and Article 29 Clause 2. In simple words, Article 15 Clause 4 creates an exception to the general rule of discrimination. The state is allowed to make a special provision for the advantage of socially and educationally backward classes, scheduled castes, and scheduled tribes. This is an affirmative action, not discrimination. Okay. And now comes the backbone case of reservation law. Indra Sahani versus Union of India. The Supreme Court held that Article 15 Clause 4 is a enabling provision. Okay. The state may provide a reservation. It is not compulsory. So the Supreme Court upheld the constitutional validity of the reservation for this particular disadvantaged group, socially and educationally backward classes. So caste can be relevant factor in identifying the backwardness, but caste cannot be the sole criteria. Introduce the concept of creamy layer. So economically advanced OBC must be excluded. Fixed 50% ceiling or total reservation except in extraordinary circumstances. So remember, Article 15 Clause 4 is about social justice with limits. Now let us move to Article 15 Clause 5. This is about admission in educational institutions. So Article 15 Clause 5 has strong non-obstantee clause. It overrides Article 15 Clause 1, Article 15 Clause 2 and Article 19 Clause 1G. So this shows the importance given to substantive equality. So this is also the enabling provision. Reservation under these Article 15 Clause 5 can be done only by law, not by the executive order. So who are the beneficiary? Socially and educationally backward classes, SC, ST. And Article 15 Clause 5 only applies to admission in educational institution. It covers government institutions, private aided institutions, private unaided institutions. But it does not apply to minority educational institutions because they are protected. So Article 15 Clause 5 was introduced by 93rd Constitutional Amendment Act 2005. So case laws. Medical Association versus Union of India. In this case, the validity of Article 15 Clause 5 was challenged. The Supreme Court held that Article 15 Clause 5 is constitutionally valid. Reservation for SC, ST and socially and educationally backward classes in private unaided non-minority institutions is allowed. Such reservation does not violate Article 19 Clause 1G. Okay. So the another case law is Pramati Educational and Cultural Trust versus Union of India. This case clarified an important boundary. The Supreme Court held Article 15 Clause 5 does not apply to minority institutions. See, minority educational institution. So this protection applies whether they are aided or unaided. So 30 Clause 1 is autonomy of minorities must be preserved. So the court harmonized Article 15 Clause 5 with Article 30 Clause 1. Okay. Now let us come to latest development, Article 15 Clause 6. What does Article 15 Clause 6 provide? It allows states to make special provision for economically weaker sections. Beneficiaries are citizens other than SC, ST and OBC. So reservations under Article 15 Clause 6 applies to Admission in educational institution includes private unaided institution, but excluding the minority institution under Article 30 Clause 1. So the maximum limit is 10%. So up to 10% reservation, and it is addition to the existing reservation. So this Article 15 Clause 6 was introduced by 103rd Constitutional Amendment Act 2019. So listen carefully. To sum up, Article 15 prohibits discrimination on the grounds of religion, race, caste, sex or place of birth. At the same time, it allows special provision for women, children, backward classes, scheduled caste and scheduled tribe. In short, Article 15 ensures equality with social justice.
For more legal updates, subscribe to the Black Letter Law Academy. Happy learning. Thank you.